Recording in progress. As such, welcome to another reading from Juridical Equity Abridged for the use of students by Mr. Charles Edward Phelps. I can't remember if he was knighted or not. A Sir comes to mind, but I don't know if that's just because it's Old English and I have a tendency to be romantic like that, or if I actually recall the fact that he was knighted for some reason. Can't remember. Anyway, good book. Forgotten Lost Books, by the way, is a great place to get reprints of books that are no longer continued. Anyway, skipping through to about there, we'll say, and we've got Chapter X. Chapter X. Principles of Equity. This is really good. There's some information here that few are going to actually be aware of. So, here we go. It starts off with number 174, How Exhibited is the title of this section under Principles of Equity. Having learned something of the principles of equity in general, as in civil, in that context, it shouldn't be in civil. General usually means in legal as opposed to equitable. However, in this context, I think that it's using it in general English. However, I'll continue. Having learned something of the principles of equity in general, of their sources, nature, extent, and of the courts and procedures which are their instruments, it is now time to examine them more closely. In their concrete form, they are exhibited as general maxims, doctrines, and particular rules. So yeah, in context, that general reference before is not legal general, that's Oxford General. If you know, you know. 175 is the beginning of the Maxims. There are a few broad and comprehensive precepts condensed into pithy and pregnant phrases, so pervading the entire structure that together they may be called the grammar of equity. Maxims are the grammar of equity. That is an amazing statement. These maxims are of different degrees of universality and importance. They are so elementary and therefore so general and vague as to require many qualifications. In their proper application consists much of the science of equity. Science of equity. Yeah. It will be seen presently that the leading maxims of equity are naturally divisible into two classes, one of the enabling and the other of the restrictive character, and one illustration of each class may be given in passing as follows. The enabling maxims are equity regards that as done which ought to be done, and restrictive maxims between equal equities the law will prevail. So you've got equities that move things forward and equities that can hold things up or make things that are stopped move forward. Doctrines, section 176. Those special systems of practical rules governing particular states of fact or branches of equity elsewhere called heads of equity are commonly known as the doctrines of equity. The same term is also employed with a more limited application. Most of these doctrines are the outgrowth of maxims. They're also called the parents, and then you get things that are the children of these things too. For instance, the doctrine of limited application. Most of these doctrines are outgrowth of the maxims. For instance, the doctrine of conversion and the doctrine of notice will be found upon examination to proceed respectively from the two maxims above cited. The methodical treatment of these doctrines of equity constitutes in fact the body of a professedly full treatise on equity jurisprudence, and does not fall within the scope of this work. Of the most useful and important of these doctrines, a sufficiently full conception for all of the purposes of elementary instruction will be obtained from the study of their sources in the maxims of equity and in the illustrations of those maxims. There's no pictures here. 176. Classification of doctrines. The older compilations were mere digests of decided cases arranged under the three principal heads: accident, as in using that term in a very broad acceptation; fraud and trust were the three principal heads: accident, fraud, and trust. Attempts at a more systemic division were made by Maddock, by Lord Reddersdale, by Josiah Smith, Spence, and Adams. Neither of these plans has met with universal approbation. The classification until... I'm going to look at that word. Approbation. A-double-P shouldn't be too long to figure out. So yeah, just before appropriate, approbate in Scotch law, to approve and reject, as in approbate and reprobate. So probate as in app, and probate as in re. Approbate is to approve, and reprobate is to reject. To take advantage of one part and reject the rest. Equity suffers no person to approbate and reprobate the same deed. So, interesting. Very interesting. Wrong page. Approbate. The classification until recently most familiar to the profession was that adopted by Judge Story following Fonblanc and Jeremy. It has the advantage of a more immediate, tangible connection with the history of the subject itself, and obviously refers to the origin of equity as merely supplemental to law. This well-known classification distributes the various subjects of equity jurisdiction under three heads, each referring directly to the courts of law. These heads are concurrent jurisdiction, exclusive jurisdiction, and auxiliary jurisdiction. For reasons already stated, the last of these three heads has become of insignificant importance, if not practically obsolete. The recent reforms in legal procedure hereinbefore referred to have obscured the distinction between the first two by removing the basis of fact that the relations between equity and law as separate systems upon which that distinction was founded so far as concerns England and her dependencies, and many of the most important and influential of those states. It may further be said that what remains of the old classification after the innovations in this state, and others that have not yet adopted the reformed procedure in its entirety, is in standing conflict with the tendencies of legislation therein. And finally, the scheme itself, judged on its merits, was one of questionable utility. The writers adopting it do not agree in their arrangement of topics under the three general divisions of jurisdiction, and are not even consistent with their own principles of classification. These topics or grounds of jurisdiction so often overlap and run into each other that the most eminent of the writers who have attempted to follow out the plan scientifically has been obliged to admit that it is impracticable and illusory. Impracticable and illusory. It is in fact admitted that with respect to the exclusive jurisdiction exercised by courts of equity in matters of trust, etc., it seems impossible to define with exactness its boundaries or to enumerate with precision its various principles. This is important. Don't get lost in this. This is important. It seems impossible to define the exact boundaries or to enumerate with precision its various principles. So we can't enact its precision around its various principles. One of the more recent English authors since the Judicature Acts rejects the division as obsolete and confusing by treating as coordinate matters of substance and matters of form, placing side by side titles so incongruous as trusts and injunctions, mortgages and interpleaders. The latest American writers on equity jurisprudence take the same view, and the classification referred to may now be said to be everywhere abandoned. It is true that the acute and analytical mind of Professor Pomeroy could not forbear the opportunity of wrestling with its difficulties in a labored attempt to explain by its aid the intricacies of equity jurisdiction as distinguished from equity jurisprudence. The sections he devotes to that discussion are most ingenious and subtle, but the least available for practical use of any portion of his profound and philosophical treatise. The method of classification of the most recent text writers on both sides of the Atlantic is substantially upon the line, somewhat obscurely indicated by Mr. Spence, but since more distinctly traced as the line of division between equitable rights and equitable remedies, or between those doctrines where the jurisdiction rests on the substantive principles of equity and those founded on the distinctive procedure. In the first division, that of equitable rights, are included equitable titles under the head of trusts, mortgages, and assignments, of choses in action, of choses, not choices, of choses in action and future property, and also equitable rights as distinguished from titles, under the head of accident, mistake, and fraud. Under the second division, the term remedies does not refer to the rules of practical procedure, but to such distinctively equitable reliefs as specific performance, injunction, reformation, and the like. The practical objection to this plan is that it somewhat awkwardly separates the right from its appropriate remedy, mistake from reformation, accident from re-execution, fraud from cancellation, trust from specific performance or injunction, thus requiring much repetition to re-establish the broken connection. The only answer to this criticism is that the nature of the subject is incompatible with any perfect system of logical arrangement, and that these various heads of equity jurisdiction, being merely the fruits of the shortcomings of the courts of common law, it might be expected that what is not a system in itself, though one is in the habit of so calling it, but only a supplement to the imperfections of another system, should hardly allow for a very methodical classification. That makes a lot of sense. How can we expect a system to be the bits where a previous system could not meet? That's a very interesting concept, and it's one that I think is logically abused in our society. For instance, in the classic scenario of where there is no evidence of something, it's considered disproven. It's like, no, just because there's no evidence of something doesn't mean it's not proof of its non-existence. But it's a very general assumption made from lay people and scientific people within their respective professional fields, let alone law. From these considerations, it results that the order to be observed in the treatment of the heads of doctrines of equity jurisprudence should be determined by practical convenience rather than by the supposed requirements of scientific precision. And the latest treatise upon the subject seems to be arranged on that plan too. 178, section 178 are the rules, and here we go. This is the interesting part that I wanted to capture in digital form for you. Preemptively set up the discussion between law, equity, what's equity versus equity jurisprudence, equity jurisdiction, prudence. And then we get into rules as well, after we've also gone through doctrines and things like this. Particular rules are the components of doctrine and are to be distinguished from the rules of court, Unlike maxims, they are narrow and definite in their scope, practical and pointed in their application. The first example below groups together a number of rules under the doctrine of conversion. The second example is a rule under the doctrine of notice. So the first example is a number of rules under the doctrine of conversion. Conversion under a will dates from testator's death. So there's one rule. Under a deed from delivery, another rule. Under a decree for sale from final ratification, another rule. And when the sale is dependent upon a contingency, the conversion dates from the happening of that contingency, another rule. All within the doctrine of conversion. And example number 2, which is a single rule under the doctrine of notice. One who takes with notice of a prior equity may resist its enforcement under cover of want of notice in his immediate vendor. Now that's an interesting one. Few actually know what vendor is, so I'm going to bring that up very quickly. Vendor! We think, it's like a food truck. Somebody sells something. And it is. But it gets very interesting because the question is, what's the difference between a salesman and a vendor? And the vendor is not the person making the sale. It's not a salesman. The person who transfers property by sale, particularly real estate, seller being more commonly used for one who sells personality. He is the vendor who negotiates the sale and becomes the recipient of the consideration, though the title comes to the vendee from another source and not from the vendor. Now, without getting too complicated in that, the fact that there is a vendor, a vendee, and a third party should give you a very big clue. (179), that's the end of rules there. 179 goes on with jurisdictional rules. There are several rules relating to jurisdiction which are too general to be subordinated to any particular doctrine, but are not usually classed among maxims. These rules have nothing to do with jurisdiction over parties, okay? Already referred to under the head of procedure. They relate to jurisdiction of the subject matter. Jurisdiction of the subject matter is in general the power to hear and determine, and more particularly the power lawfully conferred to deal with the general class of subjects to which the particular case belongs. Equity jurisdiction over the subject matter is defined negatively and in terms of the common law by the first jurisdictional rule, that equity will not assume jurisdiction where the remedy at law has always been plain, adequate, and complete. To prevent the jurisdiction of equity from attaching, the legal remedy must be as efficient as the equitable, both in respect to the relief itself and the mode of obtaining it. Generally, if a proceeding be coram no judice, that is, if the court act without jurisdiction either as to parties or subject matter, the decree is void, may be attacked collaterally. An attempt to enforce execution would be an actionable trespass, and a sale under it would pass no title. But the assumption of an exclusively legal jurisdiction by a court of equity does not necessarily make the decree void, although erroneous and liable to reversal. It cannot be questioned collaterally. The Supreme Court of the United States hold it discretionary whether to consider the objection or not, and may reverse a decree sua sponte for want of equity jurisdiction, and even where no such objection was made below. It is provided distinctly otherwise by statute in Maryland that the objection to the jurisdiction, in order to be available on appeal, must appear by the record to have been made below. point 2 here is equitable jurisdiction is in general not ousted by a subsequent expansion of the legal remedy. So equity cannot be pushed out by puffing up the legal. This rule explains the significance of the word always in the preceding rule and applies whether the legal remedy be enlarged by statute or by what is called judicial legislation. The jurisdiction is not ousted by statute unless by express terms or clear and necessary implication. Equitable jurisdiction, once having attached to a case, will be maintained for the final adjudication of all rights involved. This rule is one of the many applications of the maxim that equity prevents multiplicity of suits. Its meaning simply is that whenever jurisdiction has once rightfully attached for any legitimate purpose, it will be made effectual for the purpose of complete relief. The court will determine any incidental question necessarily involved, and the case will be retained for the final determination of all questions arising under the claim of any party interested. Or, as more briefly expressed, when a court of equity has jurisdiction over a case for any purpose, it may retain it for all purposes. The rule elsewhere is held applicable to orphan courts when exercising equity powers. The rule seems to have been never adopted in the state of New Jersey. It was at one time supposed to have lost practical importance in the code states. The consolidation of law and equity in the same suit, having removed all danger of a party being turned out of one court into another. It will be noticed, however, from the references just given to recent decisions in several of those states that the rule is still practically operative therein. The fact that the remaining questions necessary for complete adjustment are legal, or that the rights to be finally established are legal rights, or that the remedies required for their maintenance are legal remedies, will not affect the jurisdiction of equity after it has properly attached. And this principle is not an infringement of the constitutional right of trial by jury. Not. Thus, where an injunction has issued to stay a sale until certain accounts have been settled, the court may proceed to render a personal decree of for the balance due. Where the jurisdiction of equity has been rightfully invoked to reform a mistake in the policy of insurance, full relief will be administered by decree for payment. Now, all of this is the preliminary setup for section 180 here. Miscellaneous rules. In addition to the classes of rules referred to above as wonderfully networked and interconnected as they are, there are unclassified rules not referable to any particular doctrine, generally pointing the practical application of maxims. The following examples are of everyday application in practice, as in currently. A court of equity will ratify that when done, which, if previously applied to, it would have ordered. This rule will be at once recognized as a direct application of the enabling maxim previously cited above, and more fully treated further on that equity regards that as done which ought to be done. Number 2, that one of two innocent persons should suffer the loss who has most trusted the defaulter, or whose negligence enabled him to commit the fraud, or who by reasonable care could have protected himself, or whose conduct has misled others. Let me rephrase that. Who with by reasonable care could have protected himself. So, the one of two innocent persons should suffer the loss who has, by reasonable care, could have protected yourself. Keep in mind that the first legal maxim that I like to talk about for a lot of people is that ignorance is no excuse in the eyes of the law. So you can't get off on a murder because you didn't know that murder was against the law. It's a very loud example of that. Well, whose responsibility is it to be aware of the laws? Is it the states to make sure that you're aware of every single law? No, it's their responsibility to publish it and make it available for you. It's your responsibility to educate yourself. So most of the time when we hear people complaining about the fact that they're getting their equitable rights trampled upon, it's because they haven't actually met the basic component of understanding it themselves. They haven't taken reasonable care to protect themselves, and as such, the judge will side with the other party, even if it's loud and clear that your rights are being trampled over. Ignorance is no excuse. Equity does not aid those who sleep, I do believe is another one. This group of cognate rules will be found upon examination to proceed from the same restrictive maxim which is also the basis of the doctrine of lashes, classified hereinafter as the sixth restrictive maxim. Several of the cases cited in the notes illustrate the extent to which the spirit of these rules has been imported into common law. Section 181, Equities. Equities or equitable rights are prima facie well-founded claims to specific equitable relief, prima facie, such as the wife's equity, the mortgage's equity of redemption, the equities of reformation, cancellation, contribution, and the like. The wife's equity to settle out of her own property, which the husband formerly sought to reduce to his own possession by the aid of chancery, has become practically unimportant since her entire property has been secured to her by statute. As applied to other equitable claims, the term is of constant recurrence and has been imported into the phraseology of the common, especially the commercial law. In the legal sense, equities are rights incident to a property or contract as between parties, but not incident to the property or contract from its own nature. In the equitable sense, equities may be regarded as of two classes. One, primary, that is relating to rights, titles, or estates. The other, remedial, or relating to remedies. The equity of redemption is the type of the first class, and the equities of specific performance and reformation and others of similar nature are examples of the other or secondary class. Equities may be defended by superior equities, by balanced or equal equities, by lashes or acquiescence, by estoppel or election, by fraud or other inequitable conduct, or by transfer to a bona fide purchaser without notice. They differ from legal estates, liens, or charges which can be divested only by legal modes, such as the conveyance of an estate or the release or satisfaction of a lien or charge. Now, that is absolutely astounding. Absolutely astounding. I'm just going to pause for 1 second. Okay, here we go. Backing up to section 179 under part 1 here, where it says, equity will not assume jurisdiction where the remedy at law has always been plain, adequate, and complete. This is the grounds for the legal to be present everywhere and to be taken at first case, and then our agreement, our acceptance of the contract is clearly us saying, yes, the legal is clearly above board and obvious here. You know, we understand. Of course we understand. We're not idiots. We understand. Well, so we say, not realizing that we are in fact idiots and that we just believe that we're not. Idiots just meaning you don't know. Equity will not assume jurisdiction where the remedy at law has always been plain, adequate, and complete. So where there's law here, where there's legal there, they will take that as the first point of call. And so they will trample on your equitable rights unless you can pull them up on that. It's your job to prevent the jurisdiction of equity from attaching, that is, to stop equity from impeding law. The legal remedy must be as efficient as the equitable, both in respect to the relief itself and the mode of obtaining it. Generally, if a proceeding be coram non judice, that is, if the court act without jurisdiction, either as to the parties of subject matter, the decree is void, may be attacked collaterally. An attempt to enforce execution would be an actionable trespass, and a sale under it would pass no title. But the assumption of an exclusively legal jurisdiction by a court of equity does not necessarily make the decree void, although erroneous and liable to reversal. It cannot be questioned collaterally. The Supreme Court of the United States holds its discretionary whether to consider the objection or not, and may reverse a decree for want of equity jurisdiction, and even where no such objection was made below. It is provided distinctly otherwise in statutes in Maryland that the objection of the jurisdiction, in order to be available on appeal, must appear by the record to have been made below. Look, this is clear as day to me. The way in which everybody thinks that the courts are running in fraud and the judges are not listening to the founding facts of it is actually going on like this. It's clear as day, right? We do not know how to stand up in court and act, conduct ourselves, perform our, just for the sake of unified physics, our one song, our being, our presence, right? Our tone or frequency. That which we bring to the court is also accentuated by aspects of the Bible too. Paul, I think it is, has a really good section on law. I've got a video on it where he literally says, look, before you go into court, let it all go. Forget about anything. Don't walk in with this big complicated stack of what you're going to do. Walk in there with everything that you have and then leave it there at the door and then be present in the spot. And it effectively says, if you were to channel your highest capacity there, your connection with the divine, your higher self, the essence of what you are, then the individual words, the tools that will come to you are offered basically, according to the Bible, from Jesus. Like, the idea is, according to them, you walk into the courtroom and if you've done everything right, you won't speak. The Lord will speak through you. And that's where law comes from, is when universality speaks through man, but then man is obscured from understanding that and thinks that man only speaks from ego, that I speak for me. It's hard to comprehend that sometimes I might open my mouth and the universe might speak through me. With me, I'm speaking, but the universe might add something to it that makes somebody go, oh my God, the biggest problems in my world, now I see all of the solutions. These moments of divinity are cognitive phenomena that are very interesting, we'll say. It says here loudly and clearly that in all courts around the world right now, they expect it to be run in legal jurisdiction, not equity, because we're trying to make it more manageable for people. There's a beautiful way in which this is pointed out in the SDK Trust Act. For example, the 7-year time period. Imagine if we didn't have that. Nobody would be able to buy property anymore, because the people who had died, if they weren't discovered in their death, or if their death was hidden in some form or another, then the land would remain forever in their care, because nobody could prove that they were dead. Like, imagine somebody lost at sea. You would never have a body, you would never have any witness of them dying, and so even 600 years, you would still not have factual evidence of their death. You would have evidence supporting their death, but not of their death. And so as such, at a certain point in time, say 7 years from the time of last contact, if a person has yet to make themselves known, property and belongings to them can be reappropriated through other means, legal means. So that way, their mysterious death does not stop their wife, their child, from living all of the life that they could have. It also, yes, doesn't stop the state from coming in and going, "Cuckoo! and swooping off with it either. But these are the risks that we play when we fail to understand the first rule of law. I consider to be the first rule: ignorance is no excuse. Know how to play the game, and if you don't, know that you don't know how to play the game, and that you will bow out to people that do know how to play the game. And it's not just one class of people who wear special badges and go, I am a part of this particular group of people and we know everything to do with this particular subject matter. No, it doesn't work like that. There are lots of people all over the place who know lots of things. And it's all present everywhere, from historical books to Bibles and religious texts to government bits of legislation, and everything else is contained everywhere. You just need to understand the language. As in, comprehend the language, not fall under it in terms of legalese. Good example. But then, this is why I do the things that I do, and why I love stuff like the Kybalion, because the Kybalion, one of the biggest principles in the Kybalion is understanding that everything that we do is half-truths. When you walk into the world of law, which everybody thinks is all about the truth, it isn't. It's all about half-truths, and how those half-truths are positioned for people to make assumptions about the other half of those truths. But the people that use half-truths do so in ways that they don't have any grounding. And so they're trying to lead people down these roads using agreement. And when you agree to things, even if it's fraudulent, even if it's against the rules, if you agree to it, well, that's a contract. That's a legally binding agreement. That's legal. So you've just made it possible. But then legal civilization is a process of taking something that is unlawful and making it lawful through compelling argument. Okay? Literally, it's what it is. Lawful is what's right. Legal is what we can decree as right based on relative circumstance. Like, it's wrong to take property from somebody. But we don't know if this guy has been dead or if he's just moved to China, but it's been 14 years now and his children are starving because they can't return home, and his wife has nothing to do because she's trying to bounce between brothers and sisters. Then the court can, and with reasonable accuracy and humanity, turn around and go, well, we're going to give the family access to this property in order for them to mitigate the title and the deeds and the belongings and everything else. So we need to be able to break the rules. Breaking the rules is okay. How we break the rules and with whom we break the rules and whether everybody is aware of everything concerning these factors are all the biggest questions in these moments. And we will find through quick observation that if we cast our glance about our regular world of society, that for the larger part, the bigger areas of our society completely ignore those rules. And they use them to their advantage, using deception to their advantage. Anyway, thanks for having a chat with me, and thanks for listening in to how legal runs a show instead of jurisdiction. Jury. Juridical equity. I have had many conversations with people about why the courts automatically fall into assuming legal matters instead of court matters. Like, why do we get treated as persons instead of living humans? We as a body should be one maxim is the presence of the body corrects the error in law. So the presence of you being present in court should correct the assumption that they're persecuting the person. Legal. This is the legal. So in order for you to change what you need to change, there's a process for you to do that, and that's through what we call persons. And that's how the two worlds of law interact with each other. That's how you don't get crossing of interests, and I can't remember the proper term for it now. Everybody who does trust knows it. It's when you mix things around where you're not meant to be doing things against the rules. Anyway, what we have here is the outlay very clearly and loudly from 1902, I think it is, that says courts no longer operate in equity unless you can pull them into it, unless you can pull them into it, because your lawyer, I'm not going to say won't, most likely won't. I'm sure people can get their lawyer to do it if they know their lawyer, and their lawyer is capable of doing it to a degree, because the Bar Association is going to limit their capacity to do that. I know that the Bar inhibits and prevents lawyers actively in their association with the Bar from pursuing certain forms of law that would be beneficial for the people and not for the state. A Bar Association member means that the lawyer practicing has higher degrees of oaths than the oath that they take to you as a customer or a consumer. Be aware of that. Not only the oaths that you're aware of, but the oaths that you're unaware of. Secret societies, other groups and interest groups and religions and belief structures and things like this. Simple fact is, we just don't know. Thanks for hanging out, and I hope you have a wonderful day. Please do all the things. Beep, 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 beep. Share. And we're done. Bye.